our proceeding, and we would like the applicants to reply to the questions that were made yesterday. So, do you want me to?
No, it's okay.
Okay.
So we would like to answer. You asked us 3 questions, and we would like to answer on the 2 questions together because it's basically the same thing. You ask us why BH is not present at the 5 markets and to justify the number 18 for the claims, and it's basically the same question. So, in our opinion, BH was BEH, sorry, was not present on any of the relevant markets because the activities carried out in those markets were regulated and required a license, which BEH did not hold. So there is no way for BEH to be present and do activities at those markets without the license. There is also no possibility to indirectly occupy the dominant position because Bulgargas and Bulgartransgas are separated companies from BEH, and they are legally independent. And BEH is also a financial company and not gas-related company. So there is no way to indirectly occupy the market. That's the answer on the first question. And the answer, like, why we didn't answer to Sea Energy Group? Well, Bulgargas was under no obligation to provide third parties with the capacity of Romanian Pipeline 1, so there was no legal obligation for us to answer. Also, Sea Energy Group did not operate in the gas sector before. Sea Energy Group was licensed trader in electricity and licensed coordinator of a balancing group, and they just had received inquiries from customers regarding the possibility of purchasing gas, and therefore expanded scope of activities to that trade. Sea Energy Group had not yet concluded a gas supply contract with an upstream supplier, and at that time it merely intended to do so. And Sea Energy Group never contacted Bulgargas again in that regard, even though the Romanian Pipeline 1 was the only viable route for importing gas into Bulgaria. So we did not feel the need to answer before.
Thank you. Do the defendants want to reply to the answer?
Yes, Madam President, we would like to react to what the applicant have submitted. First of all, they have stated that they were not present on the relevant markets. And we want to state here clearly, once again, that they are indeed on these markets present. As we have seen from the facts of the case and from the evidence that have been gathered by the applicants and by the respondents as well, that they are present because they are the main gas supplier, and they also, the BEH company actually, does also regulate the electricity. Therefore, they are present on these markets. And second of all, we would like to react to the fact that about the refusal of the Sea Energy Group. They have stated that there were just some hypothetical, we would say, accessions to the pipelines. So therefore, they found that there was no need to react to this. However, we are submitting that this is actually a false interpretation of the Article 102 of the TFEU. Because if we would say that just because someone is looking around at the market, and we will not at the market, and we will not respond to them, then I believe that this is a clear violation of the dominant status. Because if someone is looking around and we will not just respond to them, how are we not effectively eliminating all competition, Your Excellencies? Therefore, we're submitting that these allegations are again false. Thank you.
Thank you. So now I think we can state the conclusions for the second, the third, and the fourth plea. So I leave the floor to my colleague.
Judges have decided concerning the second plea in law, alleging a failure to state reason and
I'm
errors
sorry,
of law.
Your Excellencies, may I ask? You didn't hear one of our pleadings yet. Because there
Yeah,
are
but
four
they
pleadings.
They're doing conclusions on just 3.
until
Yeah.
the second.
Yes.
Now we are
Yes.
starting
Yes.
the first.
Oh,
Okay, I'm sorry for the I'm sorry.
The second plea in law, alleging a failure to state reasons and errors of law and of fact concerning the definition of the market for capacity services on the Romanian pipeline. Regarding the first part, alleging inadequate statement of reasons for the definition of the market for capacity services on the Romanian Pipeline 1, the judges has decided that in those circumstances, the applicants cannot claim that the definition of the market for capacity services on the Romanian Pipeline 1 is not supported by sufficient reasoning, on the ground that the Commission has provided detailed explanation regarding the rationale behind such a definition. Consequently, the first part of the plea must be rejected, as the Commission's decision is deemed adequately justified and supported by thorough reasoning.
The second part, alleging the failure to analyze the market for capacity services on the Romanian Pipeline 1, the judge has decided that the applicant's argument it was mandatory that the definition of market for capacity services on the Romanian Pipeline 1 should have been preceded by a consultation with Transgas and the Romanian regulator, but must be rejected. In the light of foreign consideration, the second part must be rejected.
Regarding the third part, alleging errors of law and errors in the assessment of the facts in the definition of the market for capacity services on the Romanian pipeline, the court has decided that since that agreement remained in force throughout the infringement, it could have sold to third-party undertakings on that pipeline at the time. Accordingly, the complaints alleging that the Commission erred in law by failing to distinguish between the primary and the secondary capacity markets on the Romanian Pipeline 1, and alleging that the Commission made an error of assessment by failing to identify Transgas as being a supplier of those capacities, it must be rejected.
Regarding part 2 of the second plea, about the error of fact regarding the identification of Bulgargas as being a supplier on the Romanian Pipeline 1, it follows that the applicants complained that the Commission made an error of fact in finding that Bulgargas could provide capacity on the Romanian Pipeline 1 is unfounded. Consequently, the present part and therefore the second plea in its entirety must be rejected.
The judges have also decision for the third plea. Regarding the first part, alleging an incorrect finding that Bulgargas held a dominant position on the market for capacity services on the Romanian Pipeline 1, it follows that the Commission was fully entitled to find that Bulgargas controlled the third-party access to the Romanian Pipeline 1 during the infringement period. The first complaint must therefore be rejected. Therefore, the applicant's argument that the Commission primarily finding in the Transgas case prevented it that concluding that Bulgargas was dominated on the market for capacity services on the Romanian Pipeline 1 during the infringement. Sorry, am I reading the? Yeah, period must be rejected. The second complaint must therefore be rejected. In these circumstances, the applicants cannot validly complain that the Commission failed to access whatever Bulgargas enjoyed a dominant position vis-a-vis Transgas in the context of the decision on the renegation on the 2005 agreement. It follows that the third complaint must be rejected. As follows that the examination on the first complaint on this part of the plea, the Commission has sufficiently demonstrated in the present case that Bulgargas controlled access to the Romanian Pipeline 1 during the infringement period. Consequently, the applicants cannot claim that the Commission incorrectly concluded that Bulgargas held a dominant position on the market for capacity services on that pipeline. On the second ground, that in previous decisions, each undertaking which it had considered to hold a dominant position on the relevant market had economic, organizational, or legal links with the TSO on the transmission network in question. And therefore, on the fourth complaint, the first part must be rejected also.
Regarding the second part of the third plea, alleging an incorrect finding that BEH held a dominant position on the relevant markets, the judges have decided that the applicant's arguments criticizing the allegedly incorrect nature of the finding in the contested decision that BEH indirectly held a dominant position on those markets through its two subsidiaries cannot succeed. The Commission has thus duly established first that BEH was with Bulgargas and Bulgar-Transgas part of a single economic unit in the form of the BEH group, and second, that the group held a dominant position on the 5 relevant markets. Accordingly, the applicant's arguments criticizing that allegedly incorrect nature of the finding in the contested decision that BEH indirectly held a dominant position on those markets through its two subsidiaries cannot succeed. Consequently, this part and thus the third plea in its entirety must be rejected.
About the first plea in law alleging an incorrect finding or abuse of dominant position by the applicants. In the first part, the conduct of which the applicants are accused in relation to the Romanian Pipeline 1 is linked to the Article 17.1 of the 205 agreement, and it's based on a series of unilateral conduct, including Bulgargas application of the article. So the first part therefore must be rejected. In the second part, that case law does not preclude the application of the criteria arising from the judgment in Brunner in a situation such as in the present case, which first as follows from paragraph 261 and 263. Above, although Bulgargas was not the owner of the Romanian Pipeline 1, it enjoys an exclusive right over it, which took the form during the infringement period of a situation of control comparable to that of an owner, and where the second, although it's true that Bulgargas did not develop the Romanian Pipeline 1, the fact remains that under the 2005 agreement, it paid in return for the use of the infrastructure a fixed annual fee. Thus, consulting is an investment in relation to exclusive right which has been guaranteed by Transgas. Therefore, the second part, alleging the judgment in Broadman and the case law arising from it concerning the refusal to grant the access to essential facility, must be accepted. In the third part, it follows from the foregoing that the second complaint is well-founded. The third part, so, must be therefore accepted. In the fourth part, the operative part of the contested decision, thus interpreted, taking into account the reason which led to its adoption for the purposes of the case law citizen cited in paragraph 303 above, was therefore sufficiently clear and precise to enable first the applicant to understand the exact scope of the infringement period and to dispute its merits. And second, the court carry out its review of legality effectively. So the first part must be rejected. The fifth part, in the light of foregoing consideration, the Commission has established the requisite legal standard that the condition for the extension of the 2013 pipeline access agreement were uncertain and precise, that they placed Overgas in a position of uncertainty, and that they are as such capable of constituting abuse within the meaning of Article 102 of TFEU. Accordingly, the fifth part must be rejected.
So for the sixth part, the court has decided that, as Bulgargas argued during the administrative procedure at the time of the letter of the 26th of September 2013, it had already informed the Transgas during a meeting on October 2012 on the renegotiation of 2005 agreement of its consent to free up the announced capacity of the Romanian Pipeline 1, so as to enable Transgas to grant third-party access to it, as follows from the analysis of the eighth part of the subpleas of the third part plea below. That argument must be accepted. It follows that the sixth part must be accepted. Regarding the seventh part, the court has decided that in that context, the evidence relating to Bulgargas reservation of the entire capacity of the Romanian pipeline one under the 2005 agreement, even though Bulgargas used only part of it, it is insufficient to establish that alleged abuse on the market for the capacity of that pipeline. So the seventh part must be therefore accepted. It follows from all the considerations set out above that the only part of the first plea, the first sub-plea that must be rejected are the first, the fourth, and the fifth, and the part that needs to be that are accepted are the second, the third, the sixth, the seventh, and the eighth.
Regarding the conclusion on the fourth plea, it follows from the foregoing that the Commission has not established to the requisite legal standard that there was a refusal to grant access to the tree infrastructure held by the BEH group that was capable of falling within the scope of Article 102 TFEU as regards. It follows from the foregoing that the Commission has not established to the requisite legal standard the infringement in the form of an abuse of a dominant position imputed to the applicants by the contested decision. Therefore, the judges have decided that fourth plea must be accepted.
So we have concluded our decision. So you can go on with the first, so the last one. I leave the floor to the applicants.
I just have a question because technically they already decided like the fourth plea must be the first plea of fourth plea must be accepted. So, well, technically we won, kinda, but there is like no need for the last one to read.
Yeah,
Because they already gave. I know we were gonna read it, but still, like they already gave the decision.
But not about the law, about the first plea. It was about the fourth one.
I know, but like they already like gave about the fourth one, so there is no need for the first one because they decided that it needs to be upheld. So.
But still.
I mean, I know we're gonna read it just like it's technicality that they maybe should have. We should be speaking. We should have been speaking first about the first plea and then, like, just.
But it was about the case because in the case there was also the first one was at the end. So we are just following.
Yeah,
you know how the proceedings were in reality. So we still should.
No, you haven't win because.
Well, technically, well, yeah.
No, you won the fourth plea. You just only won second and third, if I understand correctly.
Yeah, but like the action. So
No, the judges state that it is
still going on.
an abuse
Yeah.
of dominant position.
And
The only thing that you won was that it was not a refusal to access. That's it.
Yeah, so we still need to go through the first one and then yeah.
I'm just confused because like they already like they said that something succeeded, so the action succeeded. I don't know that.
I think we can go on with the first plea. So I leave the floor to the applicants if they want to.
Yeah, just reading
On first plea.
Yeah.
Okay, first plea alleging substantive procedural defects affecting the exercise of applicants' right of defense and breach of the principle of good administration. We claim that the Commission infringed the principle of good administration and our rights of defense in several respects, which are: point A, the Commission infringed its obligation properly to record and include in the investigation file the minutes of the meetings with Overgas. Point B, Commission failed subsequently to disclose the minutes of the meetings with Overgas and certain written observations made by Overgas. Point C, the Commission deprived us of access to the statement of objections in the Gazprom case and to the underlying documents relating to the gas Bulgarian market. Point D, certain confidential information belonging to us was disclosed to Overgas. The Commission failed to fulfill its obligations as a result of the failure to send the request for information to Transgas, the owner and the TSO of the Romanian Pipeline 1. The way in which the Commission recorded or failed to record its meetings with Overgas, and the way in which it included in the file the statements made during those meetings is contrary to the recording obligations under Article 19 of regulation as we have given in the files, read in conjunction with Article 3 of the documents we have provided you with. In that way, the Commission also infringed the principles of good administration and transparency, as well as our rights of defense. As a consequence, the Court cannot exercise its power of review. The right of access to the detailed minutes of the meetings with Overgas was replaced, following numerous requests for access by restricted access through external representatives in the context of a data room procedure. The report drawn up by those representatives, which was sent to us in a non-confidential form, was because of the heavy redactions devoid of value for our defense. The confidential follow-up observations could potentially have contained exculpatory evidence, so that the access to a less redacted version of those documents would have enabled us better to exercise our rights of defense. There are a number of pieces of information which emerged from the summaries of the detailed minutes in the confidential data room report, to which we had access to pursuant to the order of 14th March 2022, Bulgarian Energy Holding and others versus Commission, which would have enabled us to ensure our defense. It is apparent from summary of the meeting of 13th October 2010 that Overgas considered that the Bulgarian government was preventing it from supplying gas to customers in Bulgaria. In particular, it is apparent from the summary that Overgas considered the Bulgarian gas supply markets to be very difficult to operate due to the incorrect and incomplete transportation of the EU directives and the constant interference of the government in favor of Bulgargas and Bulgar Transgas. It is apparent from the summary of the meeting of 13th January 2011 that Overgas considered the Transgas, and not us, controlled access to the Romanian Pipeline 1. The summary of the meeting of 15 December 2011 shows that the Commission and Overgas agreed that the first request for access to the transmission network was submitted on 29 September 2010, which confirms their position that all the contact prior to that date did not constitute request for access, and that consequently the abuse could not have started on the 30th July 2010. By refusing to grant us access to a less redacted version of the statement of obligations in the Gazprom case and to the related documents concerning the gas market in Bulgaria, the Commission denied us to access potentially exculpatory evidence, the access to the redacted version that they had through a third party did not provide us with a sufficient overview of Gazprom's conduct in Bulgaria, and that such access cannot replace the access to the file which Commission was required to grant us. The Commission infringed Article 27 of regulation of the regulations as provided, and the Commission notice on the rules for access to the Commission file in cases pursuant to Articles 101 and 102 of the TFEU, Articles 53, 54, and 57 of the EEA Agreement and Council Regulation, as the documents have been provided, by disclosing to Overgas confidential information regarding the discussion which they had with the Commission concerning their possible commitments. Thank you, judges.
Thank you. So I leave the floor to the defendants.
Thank you. Madam President, Your Excellencies, you would like to react to the first and second parts, alleging the infringement of the obligations to record and place on the file the documents relating to the Commission's meetings with Overgas, and alleging insufficient access to those documents. Your Excellencies, as soon as the applicants asked whether it had any other form of meetings with Overgas after the statement of objection, the Commission informed them of the meetings of 2015 and 2016 and sent them the brief notes relating to those meetings. And in this regards, we submit that under paragraph 27 of the same regulation that the applicant have cited, a party will be granted access to the documents received after notification of objections at later stages of administrative procedure only where such evidence or evidence may constitute new documents, whether of an incriminating, of an exculpatory nature, pertaining to the allegations concerning the party in the statement of objections. However, as we submit the documents which were relating to those meetings in 2015 and 2016 respectively, constituted neither the basis of the objections addressed to the applicants, nor new evidence as regards the allegations already made, and therefore it was the Commission had no obligation to include the brief notes or the detailed minutes of the meetings in the file. The Commission therefore submits that it did not make a procedural error by failing properly to record the statements during the meetings of 2015 and 2016, and to place them on the file, and by failing to inform the applicants of those meetings. Your Excellencies, the applicants had the opportunity to take those notes into account and exercise their rights of defense, not only by submitting their response to the statement of objections, as they have done, but also, and above all, as follows from the paragraphs 147 of the case, by submitting arguments to the hearing officer regarding their request for access to the detailed minutes, which gave rise to the grant of access in the context of a data. Therefore, we submit that the Commission did not make a procedural error. Moving on to the second complaint, Your Excellencies, regarding the access to the detailed minutes and the follow-up observations. Your Excellencies, we insist that the access which the applicant's external representatives were granted to the detailed minutes of the meetings with Overgas in the context of the data room procedure enabled the applicants to exercise their views on the information contained in those minutes, and thus to exercise again their right of defense, while respecting, of course, Overgas' legitimate concerns regarding confidentiality. We argue also that precisely because of the access to the follow-up observations of their representatives, the applicants were able to exercise not only their rights of defense, but also to raise any potential objections. In addition, we also submit that the most of the follow-up observations were not redacted, and it did not use the redacted information in its analysis that led to the adoption of the contested decision. Therefore, the allegations that they must have had the access to the detail and not redacted version are unsubstantiated, as we did not decide upon it in the contested decision. And consequently, Your Excellencies, by refusing the access to the redacted versions of the follow-up observations, and in particular the meetings of 13 October 2010 and of 13 of January and 15 of December 2011, the Commission did not make a procedural error capable of giving rise to an infringement of the applicant's right of defense. Therefore, the first and second parts must be rejected. Thank you.
Thank you. So, do the applicants want to reply? Can we make like 5-minute break to elaborate some questions?
Yeah.
So we take 5 minutes break. Okay. Do we want to make some questions to them about the 4 minutes? So, sì, cioè la forza nell'ordine
Maybe.
But
Or maybe you
they
write
read
all
everything and
together.
they-
I think we read all the plea like together.
Okay, so
Okay.
the defendant can go on with the third and the fourth
I'll check it and
Yes.
Okay.
Okay.
thank you.
In the meanwhile, I think that the defendants can go
Okay, we can continue, of course. Madam President.
on with the third and the fourth.
No, no.
Was the case? No, okay. Like, we can give you like 5 minutes to look it up. So 5 minutes.
Yeah,
Okay.
we read all
Ah,
the
you read
parts.
it all
Yeah.
together.
Oh,
Yeah.
okay.
Okay.
Okay, so
Yeah.
I leave the floor to the defendants to go on.
Thank you. Well, we would like to address the third part, alleging a failure to disclose the statement of objections in the Gazprom case. We submit that the applicants had access, even if though through a third party, to the non-confidential version of the statement of objections in the Gazprom case, which enabled them to submit a detailed supplement to their statement of reasons. Your Excellencies, it should be noted that under Article 15(1) of the regulation, as mentioned by the agents of the applicant, only the parties to whom the statement of objections is addressed have a right to access the file. Therefore, the applicants cannot claim that they have rights to access the file in the Gazprom case, held by the Commission on the same basis as Gazprom, as the undertaking under investigation, could do. In such case, in order to justify their request of access to a statement of objections addressed to the third-party undertaking, it would have been necessary, at least, for the applicants to adduce prima facie evidence of its usefulness. Your Excellencies, however, in this case, we submit that there was no evidence as to the usefulness of this evidence, and also they were not the party concerned within Gazprom case. Therefore, it should be rejected, Your Excellencies. Your Excellencies, allow me to proceed with the fourth part, alleging the disclosure of some of the applicants' confidential information to Overgas. In order to substantiate this part, Your Excellencies, the applicants rely heavily on Overgas' response of the 5th April 2016 to a request for information from the Commission of the 15th March 2016. In particular, they state that it is apparent from that response that at the meeting of 13th of October 2015, the Commission mentioned to Overgas the possibility of separating Bulgargas and Bulgartransgas structurally by subjecting those two entities to the control of different ministries. Your Excellencies, however, as the Commission contends, the applicants have not specified why the information disclosed is confidential and how this was an alleged infringement of their right to defense. For all of this, we urge you, as the arbiters of justice, to not close eyes on these injustices that have been happening. Now is the time to act, because justice delayed is justice denied. Thank you.
Thank you.
Wow, what a beautiful
I'm sorry.
Okay, thank you. So, I think, do the applicants have something to reply to the defendants?
What you
No.
are.
Do the defendants have something to reply to the applicants or to ask? I don't know.
No, thank you, Madam President.
Okay, so the judges can, we can go on with the conclusion. So of the first plea.
5 minuti.
Okay, so we take a 5 minutes break to make the conclusions. Okay, Daria, voy a pensar. Do you have the documents?
But not sure.
Is this okay? for you?
It's like,
Is this okay for you? Would you like a conclusion? It's like the last, this one. The opinion is- but it's not that.
Why?
This one.
It should be.
The first plea. And they're gonna decide.
No, this is the defendant.
It's for part of it, and I just put it together and we can.
Now it's actually.
Le rotati. Guardate a me.
Like it's very, for me, it's confusing, but like,
I don't know that, but yeah, because that's the point I'm saying. We have this judgment, but we don't have documents, and we can't do this properly. Yeah. No, this It's fun to explain my thesis.
Nessuno ha conseguenze sulle
Davvero della giustizia dipendesse da noi che decidiamo in 2 minuti per lo sbaraglio.
No, comunque per fortuna le conclusioni sulla Cile portano alla decisione positivo incorretti oppure
Però mio fratello l'altro giorno mi ha fatto uno spoiler. La volete sapere un po'? Cioè, se lui ce
Io
l'ha
l'ho trovata.
Tu come l'hai trovata?
Su internet.
No, dico come si conclude.
Ah, non lo so, me guarda,
Ah,
devo
ok, perché mio fratello mi fa che se l'ha guardato, però mio fratello è in mi fa che in realtà è finito in nulla, cioè è stato stoppato e non sono arrivati a una conclusione.
Io, no, dopo quando abbiamo la conclusione no, perché lui ha detto, vedete, se la conclusione è diversa.
sì, vuol dire che c'è una conclusione originale, ma è difficile.
Yeah, I'm already yeah, I'm already aware. I'm like,
Però sì, mio fratello fa che è arrivato tipo a una conclusione. Alla fine comunque anche noi siamo arrivati a una conclusione abbastanza pari, perché non è da dire che abbiamo rejected
Siamo stati molto equilibrati.
Sì, esatto.
riduciamo la multa.
I mean, no, like if I would, well, if I would go against the
Infatti sì, la decisione è stata
in front of the court, so you need to have everything. Like for me, the judgments are important because they create law and everything. So I don't need to have this conclusion basically.
Ecco, infatti.
You read like what happened and why they decided like this. When you're in a situation, you need
Oh, my
it's
applications are very different costs.
Ah sì, vedi, ha fatto pari, cioè le cose ha calcolato la European Commission.
No, però ha detto anche allora.
Esatto, le ha fatto ricoprire i costi all'1,90. Quindi di base non ha deciso nulla, cioè
Però noi forse dovremmo anche decidere diversamente.
Sì, ovvio, sì. Ma no, noi decidiamo in base
Sì,
a quello che
certo.
abbiamo detto noi, però è diverso da questo. Siamo pronti? Okay. So the court has decided for the first three, so if you want we can continue.
Hello.
Sorry, applicants.
Applicants
Order in the room.
Okay, so another 5 minutes
Applicants will be
break for
fined
the
for
applicants.
unprofessional behavior.
Per fortuna che non sei tu il presidente.
Siamo in fuori.
Marti dei giorni che abbiamo votato.
Sì, no, in teoria potremmo, però
Dai, lo facciamo.
Alla fine,
ci dovevano dare il martelletto. Sì, comunque lei non ci ha sbatti.
Ma devo ieri mezzogiorno.
Sì, vabbè, però secondo me c'è più da fare. Sì, infatti.
24 anni.
Ma infatti non ho capito perché l'abbia fatto. Vabbè,
È diverso.
sì, anche secondo me, perché
come si aspettava?
esatto, sì.
Secondo lei, cioè, non è una cosa.
Ale dobre, non sono stata
non è
no,
così che si svolgono veramente i processi.
Ma infatti, certo, però questa è una cosa molto approssimativa giusto per capire come funziona. Cioè, se viene fatto mi gioco anche lui, cioè è qua partecipa perché vuol dire molto più avanzato di noi,
Sì, però non
anche
è,
no,
non è che
è
pratica,
gioco.
secondo me.
Vabbè, però, cioè, anche lui potrebbe fare lo stesso.
Ma secondo me perché è stata tipo nidificata
Lui?
perché ieri invece a un certo punto
dici che
stava
questo
Lucy non lo so, però secondo me ha detto Maria se la fare apposta la storia del cecchino e io Lorenzo rispondeva
Sì, è vero.
sì, insegnava a un certo punto
Queste saranno gli altri.
sì, si è scocciata perché vedeva che replicava sempre
Everything okay? It's everything
Are we continuing or
Yeah.
we're waiting or what are we doing?
I don't know.
For me, because they're not there.
we would like to continue.
I'm
If you're
sorry, I
okay.
just needed to pick up the
Okay.
phone.
Do you need no more time?
No. We'll
Ok,
just
però teniamo un
dog
attimo.
emergency.
Okay.
Don't worry. Ok.
Martin, can we continue? Okay. So the judges have decided about the first plea. So now I will leave the floor to my colleague.
So we have made decision about the first plea in law alleging substantive procedural defects affecting the exercise of the applicant's rights or defense and breach of the principle of good administration. By the first plea, the applicant, supported by the Republic of Bulgaria, submit that the Commission infringed the principle of good administration and the rights of defense in several respects. Regarding the first and the second parts, alleging infringement of the obligations to record and place on the file the document relating to the Commission's meeting with Overgas and alleging insufficient access to those documents, the judges have decided that the first complaint claimed that the remarks made at the session with Overgas had not been appropriately documented and included in the file. Therefore, by improperly recording and filling the comments made during the meeting in 2015 and 2016, as well as by neglecting to notify the applicants of those sessions, the Commission committed a procedural error.
The second complaint regarding the access to the details, minutes, and to the follow-up of observation, in refusing the access to less redacted version of the follow-up of observation, specifically from the meeting of 13 of October 2010, 13 of January 2017, 15 of March, and 15 of December 2011, the Commission committed a procedural error that could have resulted in an infringement of the application's right to defense. Therefore, the judges have decided that it's necessary to accept the first and the second complaints of the first plea.
Regarding the declaration of objections in the Gazprom case was allegedly withheld according to the third section. So the judges have decided that it's important to highlight that the applicants have not provided any evidence in their arguments regarding the specific elements of the statement of objections in the Gazprom case that they could have used to strengthen their defense. As a result, either the first plea's third portion should be refused.
So regarding the fourth section, the fourth section makes the claim that Overgas received some of the applicant's private information for the purposes of the case law mentioned in paragraph 1152 and 1223 above. The Commission claims that the applicants have failed to specify why the material provided is confidential and how the alleged infringement of such confidentiality resulted in an infringement of the rights of defense. As a result, either the first plea, fourth section should be denied.
Our conclusion is that the first plea must be accepted, in part considering the aforementioned.
So we have concluded all the pleas. So can we take like 15 minutes to make?
So now you will have now you have coffee break.
Okay.
Okay.
Do you want
Uh,
to reply or to express
No,
your conviction? I don't know.
Sì, sì.
Possono rispondere.
yeah,
You already decided,
so
but you
there is
already
judgment.
decided,
I
so
No, we can. I don't think we can because you already decided.
Yeah.
so there's-
Yeah, okay.
No.
You want to appeal?
No,
per
no,
quello
not
cioè,
here.
per quello non gli ho detto.
Okay.
But,
Allora sono-
so you have the coffee break, but after coffee break you will have the final speeches.
Ok.
So then the final speeches they can still try to influence
okay.
somehow your opinion because of course you made some decisions before, but it's still not final judgment.
Ok.
So we have
So-
time to.
So after the final speeches,
I'm not.
let's see how long there will be. Then there will be lunch break. Actually,
Okay.
so we will have lunch at 12:15. Maybe we will be a bit earlier, but we will still need to wait for the lunch because lunch will be at 12:15.
So in the meanwhile, we can like.
And
do the
then-
final
Then
count.
after
And
lunch.
then
Okay.
you will have a lot of time actually,
Okay.
because we will start again at 3:30.
Okay.
Okay.
No, 3:15.
Three.
3:15, right? So the press conference will be 3:30 or 3:15? 3:30. So 3:30,
Sì, sì, sicuro.
and before that you will actually announce the judge. No, 3:30 you will announce the judgment. That's, yeah.
Before that, you just have to be prepared with the final judgment. You
Yeah.
can
Yes.
prepare yourself for the conference.
Yeah, so there will be final judgment, and right after that will be final conference. So the time after lunch, or maybe even before lunch,
Yeah.
you will have to prepare the final judgment, and applicants and defendants they will use that time to prepare for the press conference, and you need to be prepared for two alternatives, either that you will win or that you will
Ah,
lose.
certo.
But it still can happen, like we win part and we lose part because like we want something and they don't
That-
have to
that's the
give us
thing.
everything. So
That's
like,
the thing, you don't know
like,
what will be the final outcome, so you need to be prepared for all possibilities, and therefore you have quite a lot of time for that.
Ok.
So we have
Okay.
coffee break now.
Now coffee break.
Comunque lei che ci divertito.
I have no idea.
Esatto.
So now we can continue with our proceeding. I would like to, it's time for the final speeches, so I leave the floor to the applicants.
Your Excellencies, based on the all information given at this proceeding, we suggest in the final form of order sought in the court should adopt measure of organization of procedure or a measure of inquiry ordering the Commission to produce the statement of objection in case 80.39816 upstream gas supplies in Central and Eastern Europe, the Gazprom case, and the related documents insofar as we concern the Bulgarian gas market, annul the contested decision in whole or in part, insofar as it concerns us or one of us, failing that, annul or reduce the fine imposed on us and order the Commission to pay the cost. Thank you.
Thank you. So now I leave the floor to the defendants.
Thank you. Madam President, Your Excellencies, please allow me to summarize our pleas. Regarding the first plea, we submit that there were not any substantive procedural defects offending the exercise of the applicant's rights or defense of breach of the principles of good administration. Therefore, since the applicants had all the necessary information needed for the protection of their rights, we stand for what was said earlier in our pleadings. Allow me to continue with the second plea. The Commission does not see the factual situation being similar to the the Commission does see this situation being similar to article because BEH and Bulgargas have 100% dominant position on the market, and there is a probable limitation to the Romanian market because other gas companies do not have a possible access to the market and they don't have the same rights within their scope of skills and competence. When it comes to third plea, Your Excellencies, we submit that the Commission was fully entitled to find that Bulgargas controlled a third-party access to the Romanian Pipeline 1 during the infringement period. And now I would like to submit our fourth plea. And I'd like to state that the Commission has not produced an incorrect finding regarding the refusal of access to Romanian Pipeline 1, as the Commission has adopted firm, precise, and consistent evidence that establish the requisite legal standard, and that the conduct alleged against Bulgargas concerning access to Romanian Pipeline 1 constituted a refusal of access capable of falling within the scope of many times mentioned Article 102 of TFEU. Madam President, Your Excellencies, it's important to state that the rule of law must be upheld because injustice anywhere is a threat to justice everywhere. Thank you.
Thank you. So now we will have a break before the final judgment. So, yeah, so we have a break now before the final judgment. So, yeah.
Cool. Thank you.
Thank you.
I wanted to say thank you for the final speeches as well.
Yeah.
It's nice that you are also adding some like additional information, like what you said at the end as well, because it's nice not to only follow what is written in the document, like the formalities, but also as there's something what it's not necessarily written in like the factual background. So these kind of information or these kind of calls to action, like don't forget about justice. They wouldn't forget about it, of course. But still, it's nice to also include these like principles which should be followed. And yeah, you had it more formal, you had it more based on what was really written, but it's nice to always include something more, something going above or beyond the scope of the concrete case. That's the only thing which I would add.
Thank you. Thank you.
And the same will be for the final judgment when you
Okay,
will
so
be
we can
also
add some,
having some, that background.
okay.
Also, you can look at it from broader context
Okay.
and have some, additional information in that sense. Okay, so now you have time until lunch for working on the judgment and on the press conference preparations. Then we will have lunch at 12:15. And after lunch, you will have also time until 3:30.
Okay.
And at 3:30, we will need to start sharp because there will be also the journalist and the dean will come as well.
Okay.
Okay, I'm sorry, I have a question about the press conference.
Mhm.
I thought it was just, you said we need to prepare for it, but I
Mhm.
thought it would be like the reporters will come, they will ask some questions and we'll answer. Or should we also prepare a speech again?
That's like the final, that's the press conference. So at the press conference,
Oh.
at first you present, you react to what was said.
Okay,
It can be very short. It doesn't need to be something really. You should use some legal terms, of course, but your audience is the journalists and the public. It's not someone who is like professional.
so improvisation is fine.
So improvisation is fine, but have something prepared as well. And then they would ask you the questions, or the journalists would
Okay.
ask you the questions.
Okay, thank you.
And for the
Mhm.
judges, can you do like some examples of questions that like the journalist can do? Because
Uh-huh.
we justify our decision, but then
Mhm.
what can she ask us? Like very specific
Well,
motivations or like more philosophical meaning for
Uh,
our decision?
rather more something practical,
Okay.
like what can be the impact. I don't know what will be in your judgment.
Okay.
So, but there will be also something about the fine. So, for example, why is that fine that high?
Okay.
So the reasons which led you to the judgment. She wouldn't ask something like really philosophical, because it's also for the citizens, it's for their audience. So something very practical, like why, what can be the consequences, maybe what can be the impact on the EU law in general, if you think that there would be something,
Okay.
or if it's similar to some decisions in the past, maybe. But then you would need to go into, yeah. Or if there is some other case like that, similar case is really happening. You can, for example, say, well, there is another case submitted to us which has the similar subject matter. So probably you would decide then in the similar way, or you can say something like, okay, this decision constitutes a precedent towards the similar decisions in the past or similar cases in the future. Sorry, not past, the future. So you can also improvise in this way. Maybe there is similar case, maybe not, but we also don't know because it's maybe not public. Maybe someone prepares something. We don't know.
And every judge will be interviewed, or only the reporter?
Hard to predict.
Okay.
Journalists
So
are
the journalist can
unpredictable.
decide.
But yeah, of course.
Okay.
But then you, as the other members of other
Maybe
judges,
we
can
can
say,
prepare all together something and then
Mhm.
he will be our voice.
yeah,
You choose to be the reporter. It's your
I do
choice.
the reporter.
yeah, like the journalist will ask you something, but you
Okay.
can say, yeah, I will pass the floor to my colleague because he has everything prepared. Or you can just say something very short and then
I
pass
can
the
say
floor to
something
him.
and then give the floor to the others. Okay.
Yeah.
Okay. Bene. O se no posso farlo tutto io, non è un problema, però secondo me è più carino.
Okay,
se-
yeah.
Okay, thank you.
You can also look at the presentation which I shared in the drive because there is something written about how to communicate with media, what to pay attention to. So you can, pardon? 12:15. So it's like half an hour.
Maybe if you
Yeah.
like, if you.
Okay?
Very good.
So just don't keep yourself at the end is good.
Yes.
Se vuoi venire qua di fronte.
I need for
Yes.